Imagine a nation built on a paradox. You have this single unbreakable entity, but it's composed entirely of parts that can be erased, reshaped, or even renamed at will.
Right.
What fundamental piece of architecture, what is it that stops the entire system from just flying apart?
That's the core question, isn't it?
We're talking about a structure that the Constitution itself calls an indestructible union. Yet that same union is made up of destructible states.
And that core dilemma, that idea that the central power can literally redraw the map of its own members, but those members can't leave, that isn't just some legal curiosity.
Right.
It is the absolute foundation of India's political stability. Understanding this architecture, what we call India, that is Bharat, is, well, it's the first and most crucial step in understanding Indian polity.
And that is exactly what we are here to unpack.
Wow.
Welcome back to the Deep Dive. Our mission is to take those dense, complex, and, let's be honest, absolutely necessary foundational sources. Today we're drawing heavily from M. Laxmikanth's 8th edition on Indian polity and distill them into the essential knowledge nuggets you need. Whether you're prepping for the UPSC examination or, just want to be the most well-informed person in the room, we are your shortcut to mastery.
Our deep dive today is really focused on giving you a quick but deep and thoroughly connected understanding of the constitutional core, the dynamic role of the judiciary, and that crucial administrative machinery right down to the very foundation of the public service commissions.
Okay, before we jump into the deep end of the constitutional pool, just a quick but really heartfelt ask. If you're finding this content useful, if it's helping you structure your understanding and get ready for those tough exams, please humbly consider subscribing and joining the paid membership on the Simplified UPSC by PBP YouTube channel.
It really does make a huge difference.
It does. Your support is critical. It's what allows us to keep creating this super useful, high-quality content for the entire community. And on that note, let's give a huge, warm shout-out to all of our existing members. Your dedication is truly the fuel that sustains this entire engine. And please don't forget to like this video and share your valuable comments. It helps us reach more learners who really need this knowledge.
And remember, knowledge retention is everything. We've compiled free notes covering everything we're about to discuss, along with practice previous year questions, and they're available right now on our Telegram channel.
And for those of you who are really serious about comprehensive prep.
Yes, for you, we have premium notes. They feature extra PYQs and detailed model mains answers, and they're waiting for our legend YouTube members over on the Discord channel. So do join us there to maximize your preparation efficiency.
Okay, let's start at the very beginning. Let's establish the fundamental premise, the Constitution itself. When we talk about the basic structure, we're talking about the Grunnorm. Can you define what that actually means in simple, accessible terms?
Sure. The term Grunnorm is German for the basic norm. It's the foundational legal rule from which all other rules and laws get their validity. It is, you could say, the ultimate source of legal authority in the state. And the word constitution itself comes from the Latin term constituere, which simply means to establish.
So if the government is a house, the Constitution is the foundational blueprint. It's the rules for its construction and the charter defining who lives there and what their rights are.
That's a perfect analogy, exactly. Philosophically, it is the supreme law of the state. It lays down the relationship between the government and the people defining rights, duties, and the whole framework for governance. And structurally, it's a living document. We also have to acknowledge the distinction between different types of constitutions.
Right. We often hear about written versus unwritten. So where does the Indian Constitution fit into that classic binary?
Well, India has an enacted written constitution. It was deliberately drafted, debated, and then adopted by Constituent Assembly, all codified into one single comprehensive text.
So it's a conventional constitution.
A conventional constitution, much like the U.S. model. And this contrasts really sharply with an unwritten or evolved constitution, like Britain's. In Britain, the core principles are drawn from historical precedent, conventions, judicial decisions, various statutes that have just accumulated over centuries. The UK doesn't have a single codified document.
But just having a document isn't enough, is it? I mean, plenty of authoritarian regimes have documents they call constitutions. The critical distinction, the thing that separates a truly free state, is the practice of constitutionalism. What does that concept actually mandate?
Constitutionalism is the heart of democratic philosophy. It just means limited government. As scholars like Friedrich articulated, it provides a system of effective restraints upon governmental action. It's the idea that power, no matter how necessary or great it is, must operate within established, non-arbitrary legal boundaries.
So it's not just a declaration of power, but it's a self-imposed restriction on that power. If the Constitution is the blueprint, constitutionalism is the practice of never building outside the agreed-upon walls.
Precisely. It's the absolute antithesis of arbitrary rule and tyranny. If the state can act without legal and effective restraints, then constitutionalism has failed. It doesn't matter how beautifully written the document is. It's about applying the rule of law to the state itself.
Okay, let's move to one of the most famous critiques the framers faced. Dr. B.R. Ambedkar proudly said that they had framed the Constitution after ransacking all the known constitutions of the world.
He did.
And while that sounds like just due diligence, critics latched onto it. They called it a bag of borrowings or a hodgepodge document. How do we, as informed citizens, defend the monumental effort of the Constituent Assembly against that specific charge?
The defense is multi-layered, and it's absolutely crucial for anyone studying polity. The critique is often labeled unfair because, well, borrowing implies just copying, which is totally inaccurate.
It's not what they did.
Not at all. The framers operated in the spirit of brilliant engineering. They adopted the best practices and established principles from around the globe, but they always filtered them through the lens of Indian reality. They adapted, they customized, and most importantly, they consciously avoided the documented faults they found in those other systems.
So it wasn't about theft. It was about optimization. It was about making it fit for the unique, diverse Indian conditions. Can we trace the three main sources that shaped the Indian Constitution?
You can. We can map the core influences into three main buckets. First, you have the structural part, the nuts and bolts of governmental organization, particularly the federal scheme, the judiciary, emergency provisions. These are largely drawn from the Government of India Act, 1935. That act provided the immediate, tangible structure of administration.
That makes perfect sense, since it was the immediate operational framework they inherited. What about the philosophical underpinnings?
That's the second bucket, the philosophical part. Here we have to look internationally. The blueprint for fundamental rights, those protective shields for the individual, is clearly inspired by the U.S. Constitution.
Okay.
At the same time, the directive principles of state policy, the DPSPs, which aim for socioeconomic justice and creating a welfare state, they're inspired by the Irish Constitution. This blend reflects that dual goal of guaranteeing liberty and achieving equitable development.
And the third part would be how the government actually functions day to day.
That's the political part. This is all about the executive-legislature relationship. Our system of cabinet government, based on the principle of collective responsibility, and the relationship between the executive and the legislature, that's drawn primarily from the British Constitution. It's a pragmatic synthesis, you see, not just a collection of disparate ideas.
This synthesis brings us right back to our opening paradox, the union of states. Why did the framers, despite adopting so many features of a federation, explicitly reject the word federation in Article 1, choosing instead to define India, that is, Bharat, as a union of states?
It was a very conscious, very deliberate choice made by the drafting committee, and it was to emphasize two non-negotiable implications.
Okay, what were they?
The first is that the Indian Federation is not the result of an agreement among the units, unlike the USA, where sovereign states voluntarily came together to sign a pact.
Meaning the states weren't sovereign entities that decided to merge their power. They were more like administrative units carved up by the center.
Precisely. And the second, and much more powerful implication, is that, as a consequence, no state has the right to secede from the Union. The territorial integrity of the nation is absolute and completely non-negotiable.
That distinction, the non-negotiable integrity of the Union, is what leads directly to that core concept of an indestructible union of destructible states. How does the Constitution justify this power, and what specific constitutional tool makes the states destructible?
The tool is Article 3. This article grants Parliament the power to unilaterally form a new state by separating territory from any state, increase or diminish the area of any state, alter the boundaries, or even alter the name of any state. And crucially,
What's the process?
the process for this alteration requires only a simple majority in Parliament.
A simple majority. That's the same requirement for passing an ordinary law, not a constitutional amendment. That incredibly low bar is what makes the state so profoundly destructible.
Exactly. The process isn't adversarial or needing some two-thirds majority like it would in the U.S. The will of the center, which reflects the national mandate, is paramount in shaping the internal political map. This power is the strongest illustration of our unitary bias, and it counterbalances the otherwise federal features we possess.
So let's talk about that blend. What are those key federal and unitary features that create this structure? It's not a true federation, but more of a quasi-federal or cooperative federalism setup.
Well, we certainly have federal features, a
All
whole
right.
polity, center and states, a written constitution, the supremacy of the constitution, a division of legislative subjects in the list.
Union, state, and concurrent lists.
Right. And an independent and integrated judiciary. But, and this is the big but, the unitary features really dominate the system. You have a strong center, a single constitution for both center and states, single citizenship, the appointment of state governors by the center, that integrated judiciary we mentioned, the All India services, and of course the overwhelming power of the center during emergencies.
The power to redraw the map under Article 3, that ease of alteration, is the constant reminder that the states serve the convenience of the Union, not the other way around. Okay, shifting now from structure to purpose, let's examine the philosophical blueprint that's defined in the Preamble. This is where we articulate the ideals of the new republic. We list these big objectives: justice, liberty, equality, and fraternity, adopted on that historic day, November 26, 1949.
The preamble is really the summation of the aspirations of the Constituent Assembly. When they wrote down justice, they didn't just stop there. They specified social, economic, and political justice.
Right.
This shows an early commitment not just to formal legal equality, but to substantive equality achieved through policy. They also specified liberty of thought, expression, belief, faith, and worship, equality of status and opportunity, and making sure there was fraternity to assure the dignity of the individual and the unity and integrity of the nation.
Given its very high-minded language, how has the Supreme Court actually treated the Preamble? Was it always considered an integral part of the Constitution?
Well, the judicial view has experienced a pretty significant evolution, which is a key concept for competitive exams. Initially, back in the 1960 Birubari Union case, the Supreme Court stated that the Preamble was not a part of the Constitution.
So it was just decorative.
They recognized its value, but more as a tool to interpret ambiguous articles. They called it a key to the minds of the makers.
So insightful, but not legally binding. What caused that to shift?
The dramatic shift occurred later, and it all culminated in the Kesavananda Bharati case of 1973. Now, although the outline focuses on Birubari, understanding this progression is vital. In those later rulings, the court explicitly declared that the preamble is a part of the Constitution.
And not just a part of it.
More profoundly, it declared that the preamble contains the basic structure of the Constitution. This means the preamble's fundamental ideals like secularism, democracy, these cannot be destroyed by Parliament through amendment. It is, therefore, foundational for interpretation, even if it's not a direct source of legislative power.
That makes it less like a decorative preface and more like a non-negotiable mission statement for the entire document. Okay, let's jump into the fundamental rights, which are enforceable legal guarantees. We can start with the equality provisions, Articles 14 through 18.
These articles are absolutely critical, especially Article 15, which prohibits discrimination. It mandates that the state shall not discriminate against any citizen on grounds only of religion, race, caste, sex, or place of birth. But here's where the detail really matters. The second clause of Article 15 extends this prohibition beyond just the state.
You mean it prohibits discrimination by private individuals as well?
Yes, exactly. It explicitly prevents both the state and private individuals from discriminating when it comes to access to public facilities. We're talking shops, public restaurants, hotels, places of public entertainment, or the use of wells, tanks, roads, and bathing ghats that are maintained wholly or partly out of state funds.
So it recognizes that social discrimination, even if it's done privately, undermines public life.
It does, and it says it must be constitutionally curtailed. It's a crucial distinction, often overlooked, that fundamental rights can protect against both government excess and certain forms of private prejudice in public life.
Speaking of addressing discrimination, the Constitution adapted pretty significantly with the 103rd Amendment in 2019 regarding reservation.
Oh, that was a major amendment. It inserted new clauses into both Articles 15 and 16. The 103rd Amendment Act 2019 empowered the state to reserve up to 10% of seats for the economically weaker sections, or EWSs.
And where did this reservation apply and who was eligible for it?
It applies across two crucial domains. First, educational institutions under Article 15, and this includes private institutions, whether they're aided or unaided, though it excludes minority institutions. And second, public employment under Article 16.
Okay, and the eligibility.
The key eligibility restriction is that this benefit is available only to those EWSs who are not already covered under the existing reservation schemes for scheduled castes, scheduled tribes, and other backward classes. It was designed specifically to address economic disadvantage outside the framework of historical social backwardness.
That shows the constitutional machinery adapting to changing forms of inequality. Now let's move to the expansive, living heart of the Constitution. Article 21. The protection of life and personal liberty. This is where the judiciary has really demonstrated its role as the sentinel on the qui-vive.
The phrase sentinel on the qui-vive literally means alert guardian, and that is exactly what the Supreme Court has been. Article 21 guarantees that no person shall be deprived of his life or personal liberty except according to procedure established by law. The judicial interpretation of that one short phrase has fundamentally changed the relationship between the state and the citizen.
The list of rights that have been read into Article 21 is just astonishingly long. What are some of the most impactful expansions beyond, the mere physical act of living?
Well, the court has established that life doesn't mean mere animal existence. It means the right to live with human dignity.
Which includes?
This includes the right to livelihood, the right to privacy, the right to shelter, the right to health, the right to a decent, pollution-free environment, and even the right to free education up to 14 years of age, which was later codified by Article 21A. These expansions really confirm the constitutional commitment to building a welfare state.
But this expansive reading wasn't always the case, was it? We have to discuss the Maneka Gandhi 1978 case, which just fundamentally shifted the jurisprudence by overruling the restrictive interpretation that was set almost 3 decades earlier.
The Maneka Gandhi judgment is perhaps the most significant milestone in Indian constitutional law regarding rights. Before 1978, the 1950 A.K. Gopalan case had interpreted procedure established by law literally and very restrictively. Under Gopalan, if Parliament enacted a law, any law, no matter how arbitrary or unjust, that provided a procedure for depriving someone of liberty, the court was bound to uphold it.
So as long as the law was duly enacted, the judiciary couldn't question the fairness or the reasonableness of the procedure itself.
Exactly. The judiciary was basically powerless against arbitrary legislative action. The Maneka Gandhi case completely shattered this notion. It declared that the procedure established by law must be fair, just, and reasonable.
That sounds suspiciously like the American concept of due process of law. Was the Supreme Court essentially importing that principle?
In effect, yes. By demanding that the procedure meet the tests of fairness and reasonableness, the court injected the requirement of due process. The court argued that any procedure for deprivation of life or liberty must also satisfy the requirements of Article 14, equality, and Article 19, freedoms. This interlocking concept means that fundamental rights now exist as an integrated whole, providing robust protection against not just arbitrary executive action, but also arbitrary legislative action. It massively empowered the judiciary to guard civil liberties.
Okay, moving to the aspirational side of the coin, the directive principles of state policy, the DPSPs in Part 4. Now, unlike fundamental rights, these are non-justiciable. Why did the framers include principles that you can't actually enforce legally?
The framers understood that a newly independent, resource-starved nation couldn't possibly guarantee immediate, enforceable socioeconomic rights to all its citizens. It would have required massive state expenditure they just didn't have.
So what was the solution?
They opted to make political rights, the fundamental rights, immediately enforceable, while socioeconomic rights, the DPSPs, would serve as a moral and political mandate.
So Article 37 declares them fundamental in the governance of the country, making it the duty of the state to apply them when making laws, even if a citizen can't sue for their non-implementation. They're like a blueprint for the welfare state.
Precisely. They are meant to establish economic and social democracy. They set goals like securing a social order for the promotion of welfare, organizing village panchayats, which was Article 40, later realized through the 73rd Amendment, and securing a uniform civil code. They are aspirational benchmarks.
But their non-justiciable nature invited some pretty severe criticism. K.T. Shaw's critique is legendary.
Oh, K.T. Shaw's criticism was pointed and very memorable. He called them pious superfluities, meaning, unnecessary good intentions. And he compared them to a check on a bank, payable only when the resources of the bank permit.
That's a great line.
It is. And Nasiruddin's analogy was equally dismissive, comparing them to the New Year's resolutions, which are broken on the 2nd of January.
These critiques all hinge on their lack of legal teeth. But have the DPS keys actually translated into tangible policy? Can we link these objectives directly to historical legislative action, particularly when it comes to socioeconomic justice?
Absolutely. The DPSPs provided the constitutional justification for some of the most radical socioeconomic legislation post-independence. For instance, the pursuit of socioeconomic justice, a DPSP goal, led directly to massive land reform laws implemented across various states.
And what were the practical goals of those land reforms?
They aimed specifically at reducing economic inequalities. Key measures included the abolition of intermediaries like zamindars and jagirdars, which ended centuries of exploitative feudal structures. They also mandated tenancy reforms, so securing tenure and fixing fair rents, and they imposed ceilings on landholdings, redistributing surplus land to the landless.
So that's a clear example.
A very clear one. It demonstrated that while DPSPs aren't enforceable by the court, they were certainly enforced by the legislature. This often resulted in conflict with the fundamental right to property before it was removed as a fundamental right, of course. This tension really highlights that early struggle to balance individual rights with the goals of a welfare state.
The principles are set, but they require robust, independent institutions to execute and guard them. Let's examine the integrated judiciary, which stands as the final interpreter and guardian of the Constitution.
India adopted an integrated judicial system, which was a direct lift from the Government of India Act of 1935. This means we have the Supreme Court at the apex, high courts in the states, and then subordinate courts below them, all forming a single hierarchy.
And that's crucial because...
It's crucial because, unlike federal systems such as the USA, where you have separate federal courts for federal law and state courts for state law, our single system enforces both federal laws and state laws.
That integrated structure, despite our federal characteristics, just reinforces that unitary bias we were talking about earlier. But the integrity of that system hinges entirely on its independence, and that independence was severely tested recently over judicial appointments. We need to detail the controversy surrounding the NJAC, the National Judicial Appointments Commission.
Yes. The independence of the judiciary is considered part of the basic structure. The executive sought to replace the Collegium system, where judges appoint judges, with the National Judicial Appointments Commission through the 99th Constitutional Amendment Act and the NJAC Act of 2014.
And the NJAC would have given the executive a much bigger say.
A much greater say, along with members of civil society in the selection process.
So why did the Supreme Court view this mechanism as such a threat?
In the landmark Fourth Judges case in 2015, the Supreme Court declared both the 99th Amendment and the NJAC Act unconstitutional and void. The core reasoning was that the composition of the NJAC, which included the law minister and two eminent persons nominated by a committee involving the prime minister and the leader of the opposition, interfered with the primacy of the judiciary in appointments.
So it compromised their independence.
The court argued that this interference compromised the functional independence of the judiciary, which is a constitutional necessity.
That ruling was a massive assertion of judicial power. The Supreme Court essentially struck down a constitutional amendment, affirming that the judiciary has to retain control over its own appointments to shield itself from political pressure.
It was a constitutional crisis averted, at least in the court's view. It cemented the Collegium system's operational status. And it really underscored the judiciary's self-perception as that sentinel on the qui-vive, the vigilant guardian protecting the constitutional boundaries.
Beyond protecting its own structure, the judiciary has proactively broadened access to justice through public interest litigation, or PIL. We mentioned the relaxation of the traditional rule of locus standi. Let's elaborate on the profound impact of that relaxation.
PIL, which was largely pioneered by Justices V.R. Krishna Iyer and P.M. Bhagwati, is a truly revolutionary tool. The traditional locus standi rule meant that only the person whose legal rights were directly violated could petition the court.
Right.
But what about the poor, the marginalized, or those who are illiterate and lack the resources or even the knowledge to approach the courts?
They were effectively denied justice.
Precisely. PIL relaxed locus standing by allowing any public-spirited citizen or social organization to approach the high courts or the Supreme Court on behalf of those disadvantaged groups. It basically turns the Supreme Court into a venue for collective relief.
What are some concrete examples where PIL has been deployed to show its real-world effect on governance?
The spectrum is vast. It covers petitions relating to fundamental rights violations in jails, like complaints against police harassment or demands for speedy trials. It has addressed environmental issues, forcing industries to comply with pollution norms. It's tackled atrocities against marginalized communities, including issues like bonded labor, child labor, death in police custody. PIL functions as a direct check on administrative apathy and executive failure, where the traditional legal route is just inaccessible.
All right, let's pivot from the judiciary to the mechanisms that foster collaboration between the center and the states.
Yeah.
Cooperative federalism. How do we ensure that the two layers of government actually work together rather than constantly competing?
One of the key mechanisms is the Interstate Council, or ISC, established under Article 263. The creation of the ISC was a strong recommendation of the Sarkaria Commission on Center-State Relations, which wanted a robust, permanent mechanism for intergovernmental coordination.
And one of the primary duties assigned to the ISC?
Its core role is coordination and discussion. The ISC is tasked with, first, investigating and advising upon disputes that may have arisen between states, and second, investigating and discussing subjects where some or all of the states, or the center and one or more states, have a common interest.
So it's a forum.
It functions as a crucial recommendatory body, chaired by the Prime Minister, to ensure better coordination of policy and action. It's where disputes can be aired and common strategies formulated outside of a court setting.
On the fiscal side, cooperative federalism was really formalized with the introduction of the Goods and Services Tax, the GST, creating a body that is fundamentally unique in its structure.
Indeed. The 101st Amendment Act of 2016 established the GST Council under Article 279A. What makes this council so groundbreaking is that it operates as a joint forum of the center and the states, where decisions are taken by a weighted vote.
Can you elaborate on that voting mechanism? It's a literal sharing of fiscal sovereignty, isn't it?
It is. The center holds a voting weight of 1/3 of the total votes cast, and the states collectively hold 2/3. And decisions require a majority of not less than 3/4 of the weighted votes of the members present and voting.
So nobody can act unilaterally.
Exactly. This structure ensures that neither the center nor the states can unilaterally impose decisions. The council is mandated to recommend on everything related to GST: tax rates, exemptions, thresholds, principles governing the place of supply. It is the defining symbol of fiscal cooperative federalism in modern India.
Now we have to address the administrative backbone that seamlessly integrates central and state governance. The All India Services, or AIS.
The three All India services are the Indian Administrative Service, IAS, the Indian Police Service, IPS, and the Indian Forest Service, IFOS, which was added in 1966. They represent the single most important mechanism for national integration in the administration.
So how does the system of joint control work for these officers? They're central recruits, but they serve the states.
That joint control is the operational genius of the system. The officers are recruited and trained by the central government, often through the UPSC. However, they're allotted to state cadres and serve their initial years under the state government. The immediate control, so transfer, postings, disciplinary action, that rests with the state government where they're posted.
But the ultimate control?
The ultimate control, policy decisions, higher promotions, major disciplinary penalties, that rests with the central government. This ensures national standards are maintained while officers still retain local knowledge.
And there is a unique safeguard in Parliament specifically designed to protect state interests when it comes to creating new All India services.
Absolutely. This is found in Article 312. Parliament has the power to create new All India services common to both the center and states, but this requires a specific precondition. The Rajya Sabha, the Council of States, must first pass a resolution to that effect by a 2/3 majority.
That's a critical protection.
It is. It ensures that the states represented by the Rajya Sabha must consent before the center can expand its reach into state administration by creating new AIs.
This naturally leads us to the constitutional framework governing the public services themselves, which is the immediate concern for so many of our listeners. Let's transition into the structural foundation for the Union Public Service Commission, UPSC, and the State Public Service Commissions, SPSCs, as outlined in Part 14.
Part 14, specifically Articles 315 through 319, establishes the structure, functions, and safeguards for the commissions. These are meant to ensure impartiality, competency, and independence from political influence in public service recruitment.
Let's review these essential constitutional articles that govern the very institution responsible for maintaining the quality of the administration.
Okay. Article 315 is the foundational text. It mandates a public service commission for the Union and one for each state. Article 316 deals with the appointment and term of office members are appointed by the president for the UPSC or the governor for the SPSC, and they hold office for 6 years or until they reach the age of 65 for UPSC or 62 for SPSC.
And what ensures the independence and the security of tenure for these members?
That would be Article 317, which details their removal and suspension. They can only be removed by the president, and that's even for SPSC members, despite being appointed by the governor, and only on specified grounds, primarily misbehavior after the matter has been inquired into by the Supreme Court. This elaborate removal procedure acts as a very strong safeguard against arbitrary political removal.
What about the procedural and post-tenure rules?
Article 318 grants the authority, so the president or governor, to make regulations regarding the conditions of service for the members and staff of the commission. And finally, Article 319 dictates the prohibitions on holding office after ceasing to be a member. This article is absolutely vital for maintaining post-retirement neutrality.
Focusing on the SPSC details, what specific prohibition exists under Article 319 that ensures there is no hope or expectation of further governmental employment in the same role?
A critical detail here is that a chairman or a member of a state public service commission is not eligible for reappointment to that same office after their first term.
So no second term in the same job.
No. While they may be eligible for a higher position, like UPSC chairman or member, they cannot simply secure a second term in their initial SPSC role. This, along with the prohibition on taking any other government job after retirement, minimizes the possibility of members being influenced by the executive while in office in the hope of future favors. The SPSCs, just like the UPSC, perform the essential function of conducting examinations and advising the government on recruitment methods for civil posts within the state services.
We transition now to the most potent centralizing constitutional provisions, the emergencies. These are the moments when the entire federal structure just morphs into a unitary one. However, the experience of the 1975 emergency taught some very harsh lessons, resulting in vital constitutional and judicial safeguards against executive overreach.
The abuse of the national emergency provision, Article 352, led the judiciary to assert its final authority. In the famous Minerva Mills case of 1980, the Supreme Court ruled that the president's power to proclaim a national emergency is not absolute.
On what grounds did the court establish for judicial review?
The court established that the proclamation can be judicially reviewed on the limited but important grounds of malified intent, or if the declaration was based on extraneous and irrelevant facts, or if it was, perverse and absurd. This ruling reaffirmed that the principle of limited government constitutionalism applies even to the extreme measure of emergency.
So presidential satisfaction is not beyond question.
It cannot be placed beyond the reach of the judiciary.
But the most significant statutory safeguard against emergency excesses came from Parliament itself, via the 44th Amendment.
The 44th Amendment in 1978 was a direct legislative correction of the 1975 emergency's most chilling effect. It established that the fundamental rights guaranteeing the right to life and personal liberty, Article 21, and the right against arbitrary arrest and detention, Article 20, cannot be suspended even when a proclamation of national emergency is in operation.
And this was a necessary response to the Supreme Court's deeply criticized stance during the emergency.
Oh, absolutely. It was the only way to permanently fix the damage caused by the infamous ADM Jabalpur case in 1976. During that case, the majority judgment effectively held that once fundamental rights were suspended by presidential order, a citizen had no legal recourse, not even the writ of habeas corpus, to challenge detention even if it was illegal.
Unbelievable.
The 44th Amendment ensured that even in the darkest constitutional hour, the right to life remains sacrosanct and enforceable.
Moving to legislative accountability, how does Parliament enforce control over the executive? Specifically, what is the clear distinction between a censure motion and a no-confidence motion?
Both are tools used in the Lok Sabha to hold the Council of Ministers accountable, but they differ significantly in scope and consequence. A censure motion is limited in scope. It has to state the specific reasons for its adoption, usually targeting failure in specific policies or actions, and it can be moved against an individual minister, a group of ministers, or the entire council.
So it's a specific reprimand. And the no-confidence motion.
That is the nuclear option. It does not need to state any reasons for its adoption in the Lok Sabha. It simply asserts that the House has lost confidence in the government. And crucially, it must be moved against the entire Council of Ministers only. If it passes, the Council of Ministers must resign. It brings down the entire government, unlike a censure motion, which is merely a strong disapproving message.
Finally, let's address legislative stability, through the Anti-Defection Law, which is codified in the 10th Schedule. It's designed to prevent the constant switching of political loyalties.
The 10th Schedule, introduced back in 1985, is designed to curb political defections that are motivated by the lure of office or material benefits, which had historically destabilized state governments. It mandates disqualification under 4 primary conditions.
Can we detail those 4 core conditions for disqualification?
Sure. First, if the member voluntarily gives up the membership of the political party that elected them. Second, and this is the most commonly tested, if they vote or abstain from voting in the House contrary to any direction or whip issued by their political party without getting prior permission.
Okay.
Third, if an independently elected member joins any political party after their election. And fourth, if a nominated member joins any political party after the expiry of 6 months from taking their seat.
And who holds the decisive power over these disqualifications, and is that decision truly final?
The power rests with the presiding officer, Speaker in the Lok Sabha and the Chairman in the Rajya Sabha. This decision was initially outside the scope of judicial review, which was a point of immense controversy.
Well, that changed.
Yes. The Supreme Court, in the landmark Quijano-Holohan case, 1992, ruled that the decision of the Speaker or Chairman is subject to judicial review on grounds of malified intent or violation of constitutional provisions. This ensures that even internal legislative disciplinary actions remain accountable to the higher constitutional standards.
This has been an incredibly detailed journey through the constitutional core of India. We started by appreciating that blend of federalism and unitary power that creates the indestructible union of destructible states, realizing that the strength of the center is a deliberate choice for national unity.
We then explored the dynamic expansion of fundamental rights, noting how the judiciary, particularly through the Maneka Gandhi case, really imported the principle of substantive due process. It transformed Article 21 into the most powerful constitutional guarantee against arbitrary action.
A guarantee that's reinforced by the 44th Amendment, even during emergencies.
Exactly. And crucially, we detailed the machinery of governance, the collaborative function of federal bodies like the GST Council under Article 279A, and the foundational framework for public service. Understanding Articles 315 through 319 is so vital as they govern the independence, recruitment, and function of the UPSC and the SPSCs, the very spine of the Indian administration.
So, to leave you with a final provocative thought that connects the constitutional text directly to internal security, we've discussed how the DPSPs and other foundational articles are mandates for justice. What happens when these foundational constitutional mandates fail administratively?
That failure can have catastrophic real-world consequences. It can transform what seems like academic policy into very real security threats.
I see where you're going with this.
Precisely. Consider the constitutional provisions under the 5th Schedule. These relate to the administration and control of scheduled areas and tribal populations. A major previous year question asks about the impact of the non-implementation of these provisions.
And the linkage is stark, isn't it? The failure to administer tribal areas justly, to protect their land rights and resources as mandated by the Constitution, leads directly to deep alienation, which then fuels internal security challenges like left-wing extremism.
Naxalism. It illustrates the high stakes of polity. The constitutional text isn't merely academic theory. Its successful, timely, and just administrative implementation is essential for maintaining the integrity, peace, and security of the Union itself. The failure to govern under the constitutional mandate can breed violent resistance.
A truly profound perspective. It reminds us why a deep understanding of governance is just so paramount. Thank you for guiding us through this essential deep dive.
My pleasure.
And to our fantastic listener, thank you for joining us. If you found this comprehensive analysis and the connections between theory and real-world application valuable, please remember our essential call to action. Subscribe, like this video, and share your comments. And if you're able, joining the paid membership on the Simplified UPSC by PPP YouTube channel helps us sustain this detailed, continuous effort for the entire learning community.
And don't forget to access your detailed notes now. Remember, free notes with practice PYQs are available on our Telegram channel, and premium notes with extra PYQs and model mains answers for mains questions are waiting for our legend YouTube members on Discord. Do join the community.
We look forward to seeing you there. Keep learning, keep diving deep, and we'll catch you on the next deep dive.